Hi, my name is David Shapiro, San Diego-based criminal defense attorney, and today I'd like to talk to you about statutory rape charges in California. Statutory rape is usually governed by Penal Code Section 261.5, and what statutory rape means is a lot of times consensual sex between two people, one of which being under the age of 18. So even though both parties consented, statutorily, under the law, the age of consent is 18, so that would be an illegal act. Statutory rape, a lot of how these cases are prosecuted, if they're even prosecuted, the accused and the alleged victim. If there's less than a 3-year age difference, so say for example, if the accused is 19 and the alleged victim is 17, at worst usually we see these cases charged as a misdemeanor. If there's more than a 3-year age difference, that person could be facing up to 3 years in custody. If you're in a situation where the person's over 21 and the minor is under the age of 16, you could be dealing with up to 4 years in custody. And if they're under 14, you could be dealing with the lewd and lascivious act on a child, whether there's consent or not, and you could get up to 8 years in state prison at 85% of that time. So the age is very important. Many times we see these relationships corroborated or confirmed on Facebook conversations, on text messages, on admissions. So you have to be very careful. A lot of times you get calls, hey, I'm 19 years old, my girlfriend's 17, she's pregnant. Am I going to get charged? Am I going to get convicted? Well, the age difference in that situation is less than 3 years. So at worst, you'll be looking at a misdemeanor. Can the district attorney, can the city attorney charge you with those offenses? Yeah, they certainly could if they could prove it. That you guys had some inappropriate, at least under the law, sexual relations. I think it would be hypocritical of a lot of people if you're dealing with a situation where, hey, this guy's 18 and a half and his girlfriend's 17 and they had sex or they had sexual relations. Well, a lot of people will be charged with those offenses throughout the course of time. I think the main driving force a lot of times is how the alleged victim's parents are dealing with it, if they're pushing hard for prosecution, and also issues of proof. If the person goes in there, yeah, we've been doing this for this long and I was this old and she was this old, you're giving them a case on a silver platter. So the age difference makes a factor as well. The strength of the case makes a difference as well. So if you're alleged or if you get a call from your girlfriend's parents and they're like, hey, what are you doing? How long have you been messing around with my daughter physically? Keep your mouth closed. Be polite. Be respectful. Don't answer those questions. Contact an attorney who can be polite, be respectful, be professional, and deal with these allegations without throwing you under the bus and without you throwing yourself under the bus by admitting there was any illegal conduct under the law. So, statutory rape in summary, the age difference makes a big difference, but keep your mouth closed because you still need to prove there were some relations, and consent is not a defense to statutory rape. So keeping those three things in mind, make sure you hire yourself a good attorney if ever accused or under investigation for Penal Code Section 261.5 or anything related to inappropriate actions under the law with a minor.